Welcome to U.S. Immigration TV. I have an important breaking news update on the Child Status Protection Act, or CSPA, so make sure to watch this video until the end as it may benefit your child. Well, on Valentine's Day, February 14, 2023, the U.S. Citizenship and Immigration Services, or USCIS, announced a major change in determining when a visa is available for purposes of calculating a child's age under the Child Status Protection Act. Now, under this change in policy, more children could be eligible for CSPA age-out protections, as the computation of the child's age could be performed years earlier than under current practices. Now, this change in policy is effective immediately and applies to adjustment of status applications adjudicated by USCIS on or after February 14, 2023. Now, a little bit of background. Previously, both the Department of State, or DOS, and the USCIS used the final action dates on the monthly visa bulletin as the date for determining when a visa becomes available for purposes of calculating a child's age. Now, in October 2015, DOS began publishing two charts in the monthly visa bulletin, consisting of one, dates for filing chart, which notifies beneficiaries when they may assemble and submit required documents to the NVC, or National Visa Center, and second, a final action dates chart, which informs when a visa is authorized for issuance or priority dates current to have the visa issued. Now, since this change in 2015, each month the USCIS designates one of these two charts, the dates for filing or the final action dates, for applicants to use in determining when they may file adjustment of status applications in the U.S. Now, in almost all cases, the dates for filing chart was earlier or sooner than the final action dates, and that allowed more people to file for adjustment of status and obtain work authorizations while waiting for the priority date on the final action dates chart to become current. However, USCIS still considered a visa available for CSPA calculations based on the final action dates chart. Now, in changing its policy, USCIS pointed out that a potential CSPA eligible child could go ahead and file adjustment of status, pay the filing fees, based on the dates for filing chart, without knowing if they would eventually be qualified for age-out protection based on the final action dates. Now, to address this issue, USCIS has updated or changed its policy, what I consider for the better. They now consider a visa available in order to calculate the child's CSPA age at the same time USCIS considers a visa available for accepting and processing of adjustment of status applications. Now, this will be based on whether USCIS relies on the dates for filing or the final action date charts. Now, using the dates for filing chart could greatly benefit CSPA eligible children, as the age calculation could be performed years earlier. Now, let me give you an example which I hope will clarify things. Now, in the March 2023 Visa Bulletin, the dates for filing for single adult children, F1, for the Philippines is April 22, 2015. That's the dates for filing. However, the final action dates is March 1, 2012. So on its website, USCIS has already indicated that applicants should use the dates for filing chart in connection with filing adjustment of status. Therefore, if the F1 priority date is earlier than April 22, 2015, the dates for filing date chart, the principal and all their beneficiaries, their children, may file adjustment of status if otherwise eligible. And I'll get to that in a minute, if you're eligible. Well, under the new policy, the child's age would now be calculated using the April 22, 2015 date for visa availability, whereas previously, the child would have to wait until that March 1, 2012 priority date became current in order to calculate their age. So they basically are able to calculate the age or get a 3-year jump on when they're considered eligible under the Child Status Protection Act. Now, I understand that determining a child's CESPA eligibility is extremely complex and confusing. It involves taking into account the DOS's monthly visa bulletin. Then you have to refer to the USCIS website to determine which of the two charts they're relying on, the dates for filing or final action dates, in order to perform the mathematical computation. And if they are eligible under the Child Status Protection Act, they must also separately seek to acquire their visa or file adjustment within 1 year. Also, as I said before, they have to be eligible to file for adjustment of status, such as being in status, having the benefit of Section 245I, etc. Also, and this is important as well, while the USCIS is adopting this new policy of relying on the dates for filing dates, the Department of State or the embassies are still using the final action dates for calculating a child's CESPA age as of now if they're being processed overseas. That's why, if your child's adjustment of status was previously denied because they aged out, but you believe they could now benefit under this new policy, or if you have any questions concerning a child who is potentially eligible under the Child Status Protection Act, you should consult with an attorney who can evaluate your case and determine which of the two charts to utilize, and the attorney could also do the mathematical computations, or the attorney can bring a motion to reopen on a previously denied case. Now, I hope you have found this video helpful and informative, and of course, I will continue following and monitoring the development in the Child Status Protection Act, as well as other immigration developments that may be of interest to you. So therefore, make sure to like, share, and subscribe to this channel. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.